What is interesting to note in this case is that the husband claims that he has paid the amount of rupees 40,000 to the wife on 25/11/1995, upon which the wife has relinquished her past and future claim for maintenance, and also did agree to withdraw the criminal prosecution launched against the husband for the offence punishable under section 498A of the Indian Penal Code. Stop. But then, if it was so, nothing prevented the parties to make a mention of the same either in the consent deed or in the customary deed. Stop. In absence of any evidence on it, except bare words of the husband to show that the amount of rupees 40,000 was paid to the wife, it is not possible to accept that the consent deed executed by the wife was voluntary. Stop. The learned magistrate has considered these circumstances and recorded the finding that in the aforesaid circumstances it is very difficult to digest that the wife voluntarily executed the consent deed and divorce deed and to relinquish her right of maintenance for past and future stock. The circumstances reveal that the wife might have put her signature on the consent deed and divorce deed without reading the consents thereof. Stop. More so because that before executing the aforesaid documents, the husband had filed the Hindu marriage petition for divorce in the competent court, which came to be dismissed on 21/6/1993. Stop. The compromise memo filed in criminal prosecution launched by the wife for the offence punishable under section 498A read with section 34 Indian Penal Code clearly discloses that the matter was compounded between the parties on the condition that the husband was ready to maintain the wife at his house, and in the aforesaid circumstances the possibility cannot be ruled out that the husband had taken the signature of his wife on the consent, making her to understand that he would behave properly with her and would not subject her to cruelty and ill treatment. Stop. In such circumstances, the magistrate had rightly recorded the findings that the wife cannot be said to have executed the consent deed voluntarily and that she has given up her right to claim past and future maintenance. Stop. The additional sessions judge has committed an error in reaching the conclusion that since the wife is living separate by mutual consent and that since she had obtained the divorce and relinquished her claim for past and future maintenance, she is not entitled to maintenance under section 125(4) of the Code of Criminal Procedure. Stop. He did not apply his mind while considering the decision of this court in the case of P versus N 2001 civil court cases 5 to 7 Bombay 2001 MLJ case 2002, and therefore the impugned order has resulted in two miscarriage of justice and cannot be sustainable in law. Stop. In this single bench decision of this court, it has been held that the revisional court had not applied its mind properly to the evidence with respect to the alleged divorce deed. Stop. not establish that there was such a custom amongst their community stock. In fact, it was nowhere on record as to what community the parties belonged and whether there was a custom amongst their community to put an end to the relationship of husband and wife by way of mutual consent. Stop the reversional court erred in applying the law so as far as right of the wife to maintenance under explanation within bracket B to section 125 within bracket 1 of the Code of Criminal Procedure 1973, assuming that there was a divorce by mutual consent. Stop, since the petitioner wife had not remarried after her alleged divorce, she is included in the definition of wife as per explanation within bracket B to section 125 within bracket 1 of the Code of Criminal Procedure 1973. Stop. There is no exception even though divorce was allegedly by mutual consent. Stop. Order of the sessions judge set aside restoring the order of judicial magistrate